so what I have here is on Mr. Coleman. He had a misdemeanor charge of domestic violence against LaMonica Coleman. And then that is alleged to have occurred on January 28th of 2025. Then there's another allegation on April 1st of 2025 with the same complainant, and it's a charge of assault with intent to commit great bodily harm less than murder, and another charge of domestic violence. And I have in front of me a motion to amend the bond.
Your Honor, is the misdemeanor domestic violence, is that a city case or a state case?
That one's a city.
Okay, then, Your Honor, based on the fact that we have the same complainant in this case, and then a very serious felony of assault with intent, great bodily harm, it shows there's escalation in this matter. People do oppose the modification of the bond, believing that it was a fair and reasonable bond that was originally set.
And counsel, is there anything you want to tell me?
Your Honor, I won't. Your Honor recognized that I filed a motion. I'm not going to rehash everything that's in my motion because I think it articulates properly exactly why Mr. Coleman deserves a bond in this instance. But I will highlight the two things that I think should most assuage any concerns that the court has. The first being Mr. Coleman is ready, willing, and able, very voluntarily, to wear a tether. And this court has two major prongs to consider when it's evaluating bond. This court well knows that those two prongs are likelihood of returning to the court and keeping the community safe. Your Honor, a tether would accomplish both of those goals. The minute that Mr. Coleman does not show up for court, deputies could find his exact location, bring him right back to the jail, ensure that he shows up for court, and then the court would have absolutely no reason to give him a bond after that instance. Your Honor, ensuring that Mr. Coleman wears a tether would also protect not just the community at large, but it would protect the complaining witness in this case by providing the court the opportunity to institute exclusionary zones from the complaining witness's home, frequently visited areas, job, anything that makes the court comfortable that Mr. Coleman will have absolutely no contact with the complaining witness. And Your Honor, in addition to the security that a tether would provide, I would posit, Your Honor, that the second thing I would ask this court to greatly consider is Mr. Coleman's ties to this community. Mr. Coleman has extensive family throughout this community. They have been in contact with me on a daily basis about Mr. Coleman's cases. They are the ones who are putting up money for Mr. Coleman's defense. They are the ones who are going to put up the money for Mr. Coleman's bonds. They have a vested financial, personal, familial interest in ensuring that Mr. Coleman not only shows back up for court, but also in ensuring that he does absolutely nothing to put himself in a position where he could go back to jail. And he knows, and everyone in that family knows, that that means absolutely no contact with the complaining witness. And those two things working in conjunction here, the familial support and the threat of going back to jail on a tether, would both protect the community and ensure Mr. Coleman returns to court. I believe that there is a less restrictive option, which I would ask this court to consider, than incarceration that will accomplish the court's goals.
Okay, I just need 1 second. I need to look at something that's not in the file. So let me pass this while we contact the clerks and get that up here, and then I'll make a decision.
Thank you, Your Honor.
Thank you, Your Honor.
So I didn't set the bond on the state case, but on the city case, it looks like his bond is currently $5,000 cash or surety. Is that your understanding as well? You're muted.
It is now. Thank you, Judge.
And that's your understanding?
Yes.
Okay, here's my concern. He's got bench warrants for traffic. The allegations in this case, they're just allegations, but I do have to make a consideration with respect to public safety and specifically the safety of LaMonica Coleman. And here I have an individual in front of me who had a domestic violence. The allegations are that on the felony case are that he went into her home while she was sleeping, went into her bedroom, and
No, ma'am.
Your Honor, I'm sorry. If I could just interject really quickly. Mr.
Wait.
Coleman, please mute your device.
yeah, there's a lot of, I mean, these are allegations. I understand that, but there's something I really have to take into consideration. So I have someone in front of me who has a domestic violence pending. They get this other case. The allegation is she was in bed, felt like someone was in her home. There was a minor child in the home. They were not residing together. And she woke up, grabbed her phone and began to call 911. And the defendant then appeared from the floor next to her bed and began to choke her. There's also an allegation that he was making threat. He then chased her down the stairs. These are allegations, and began choking her on the couch. And told her he was going to kill her, and that she actually passed out and woke up by him pouring water on her face. I mean, it wasn't, you know, sometimes the prosecutor's office, if you put hands on someone's throats, you get charged with a 10-year felony. And sometimes I think, you know, that's what the law says and I'll follow it. But then there are situations where someone chokes someone while threatening to kill them and sneaking into their house, at least the allegations, and then they choke them to the point of unconsciousness. And to me, that is incredibly serious. I believe the threat to the complainant in this case is grave. And I am not going to modify the bond on that case at this time based on the allegations matched with the fact he did have some bench warrants. There's another domestic violence case pending with the same complaining witness. And I just think all of that together, I mean, it's very concerning to me. And the bond is the $5,000 cash with the GPS tether.
Judge, thank you. We understand and appreciate the court's ruling. We appreciate the court seeing us today. We understand today is not a state law day. Your Honor, just procedurally speaking, I understand that the court is not amending the bond today. That is on, I believe, the city case. Is the court open to me readdressing the issue of bond on the state case at our next date?
Yeah, but yes, you can readdress bond. But
Mr.
that
Coleman,
one,
mute your
you
device.
had
I'm
a
sorry.
personal bond on it set by the other judge here. Not me. And he was given a GPS tether on that case.
Okay, so Your Honor, if I could just ask for clarification, because the court's website indicates that Mr. Coleman is on remand for that case. Actually, for both cases.
Not what my bond paperwork says that I have on the files. I don't know if he has another hold.
So Your Honor, if I could ask you to restate that, you said on the state case.
That's what it says on my bond paperwork. The state case was a $20,000 personal bond with a GPS tether. And then the misdemeanor case is a $5,000 cash or surety bond with a GPS tether. And they're set by different judges. So he saw me, I arraigned him. No, he originally had a $1,000 bond set on the misdemeanor case. He didn't appear for court. And then he was given a $5,000 cash or surety bond.
Okay, Your Honor, I appreciate the court very much. Mr. Coleman will attempt to pay those bonds, and if there's some confusion between the clerk's office and what's on the court's file, I'll bring that to the court's attention at the appropriate time. Again, we do appreciate the court seeing us on a non-state day. We understand that you and your clerk made an exception for us, and we are grateful for that.
1 second, because we're talking to the clerk downstairs, because my ROAs ends after a certain date. Hold on. His bonds were denied by Judge Slaving for failing to appear at the arraignment. So, or I'm sorry, at the probable cause conference. So in the misdemeanor, it looks like they're both bond denied. At this point, I don't necessarily think that's appropriate, but I need a prosecutor here. Because I need the state prosecutor to talk to me on that felony, and I think we need to address it when you're present and Mr. Louis is present as well. So,
Your Honor, I understand that. That makes total sense. I heard you say Miss Louis. I did send a courtesy copy of my motion to Miss Murad. Is she no longer your state court prosecutor on Mondays?
we have gone through several. It's Miss Louis now.
And is that ALOUIE?
That ALOUIE. Do you want her bar number?
Oh, that would be great. Yes, thank you.
I was just gonna say, I'll have the court clerk put both of these on Monday, because we have to hear this and address these, obviously. So I'm just gonna put a note to the clerk to squeeze it in Monday at 9, and we'll figure it out.
Judge, I will be here Monday at 9, also via Zoom, correct, Your Honor?
Correct, yes.
Okay, thank you very much. I've got that on my calendar. Your Honor, I suppose my only request to this court at this point in time is that if this court was willing to allow Mr. Coleman to have a $5,000 cash bond on the misdemeanor case, and that is a case that Mr. Zick can handle, I would ask that the court institute that bond on that
No.
case alone at this time.
Here's the problem. I don't know anything about this case. We put it on today for an emergency motion. I didn't have an updated ROA in the file. Okay, and I know my benchmate, and if he believed that no bond was appropriate, that is very unusual. I can't imagine what the circumstances are, or if there are things I don't know, and I am not touching these until I've had a chance to have you and Miss Louis present. I'm not doing it. And then of course I'll readdress bond after I hear testimony at the exam. Okay, but until Monday, I'm not modifying anything without both of you present.
Judge, understood. Thank you.
All right. All right, we're all set. Thank you.
All right, thank you, Your Honor. We'll see you on Monday morning.